to do business. Thank you, Mr Speaker.
I call the Honourable David Parker.
Thank you, Mr Speaker. The Labor Party will be supporting this bill to Select Committee, as the Honourable Clayton Cosgrove has already indicated. I want to start by asking, in response to the comment that was made by the last speaker on behalf of the National Party, that this matter came to the knowledge of authorities in 2010, were his words, and I'll take him at his word on that. 2010, 2 years later, we're considering the first reading of this bill, and the question has to be asked why, after 2 years of knowledge of serious fraud being committed around the world in a way that besmirches New Zealand's reputation and therefore imposes long-term costs on the New Zealand economy for our businesses whose ease of doing business in offshore jurisdictions has been undermined by these instances of fraud, why it is that the government has taken 2 years to get this bill from 2010 to 2012 into a first reading in this House. We know that New Zealand has a long-standing reputation that's taken approximately 2 centuries to cement in place as being one of the least corrupt countries in the world. We know that because we are very good at using information technology to reduce business compliance costs in New Zealand, that New Zealand is an easy place to form companies, and we've known for some years now that some people have been taking advantage of that ease of setting up a company, of the lack of checks and balances as to whether people are telling the truth when they are filing the documents that are filed via the internet when they form a new company, and yet we've had such a lax approach by this government that has taken 2 years from the date when these problems became evident in 2010 for them to take some legislative step to bring about a remedy and protect New Zealand's reputation overseas. Now, what's been the consequences of that in the meantime? Well, New Zealand has already been taken off a low compliance white list in some overseas jurisdictions. Until we were struck off this white list in Europe, the European banking system was able to rely upon documentation originating from New Zealand as evidence that the entity was non-corrupt. They could take these things at face value because New Zealand had a reputation for properly policing our system and pushing against corruption, which is one of the reasons why, until now, we have been seen by Transparency International as one of the least corrupt countries in the world. But because of the lack of speed, the lack of alacrity with which we responded to these problems that were being experienced, we've been struck off that white list, which means that the banks and the other institutions in the European Union are no longer entitled to carry out a simplified level of research, and they can't accept and acknowledge customer identification and corporate identification at face value now, and that is of detriment to every New Zealand company which operates in Europe and has dealings with these European financial institutions, who now have to be satisfied with more information being provided by the New Zealand corporate, which no doubt increases their compliance costs as a consequence of this problem not being remedied earlier. Mr. Speaker, the bill also enhances, not only has restrictions on registration of companies, it enhances the registrar's ability to investigate allegations of ill-dealing and deregistration powers for companies and, as the Minister rightly said, limited partnerships, which, if they weren't covered, could be used as substitute for incorporated structures. There are some preconditions that are set out in the bill. Obviously, the registrar has to have reasonable grounds before they exercise these powers, otherwise we could be creating other injustices. Or if the registrar writes to the companies concerned and doesn't get a response from these companies because, using the example that Jonathan Young referred to, where there was some front of a Queen Street address where someone in the fast food industry had registered companies on behalf of somebody else, it's likely that if there were queries put to that person by the registrar of companies, they wouldn't get an adequate response, or in fact they might get no response because the address might be fictitious or old. And in respect of those instances where the registrar doesn't get a response or doesn't get other information to confirm the correctness of information that might have been provided, then the registrar is there's a discretion for the registrar to strike those companies off. And indeed, even before strike off, my understanding is that the bill confers some powers that they can put warnings on the register, so that if someone is accessing via the internet those registers, and that could be someone in New Zealand, but it could also be someone that was having business dealings with them in an offshore jurisdiction, could see that the registrar of the New Zealand Companies Office had some concerns, and they might have cause to doubt whether they should take the information at face value and look a bit further. And that will improve New Zealand's standing in the international community, and therefore make it easier for New Zealand to both protect our reputation and for our legitimate corporates to go about their business, because we'll be taking a step to protect their legitimacy and the trustworthiness with which they're viewed by overseas people. There are also other amendments which are unrelated to this aspect, which relate to takeovers and amalgamations. Currently, there is a route under the Companies Act 1993 that enables schemes of arrangement, and including amalgamations or compromises, that act a wee bit like mergers, to go outside the rules that relate to the Takeovers Code. So the protections that lie, for example, with minority shareholders, or requiring a certain level of shareholder support before a takeover can be put into effect under the Takeovers Code, have had this alternative route under the Companies Act, which they have been able to utilise in a way that avoids the Takeovers Code. This legislation makes changes to ensure that companies that are meant to be covered by the Takeovers Code cannot be, or the shareholders of those companies can't be disadvantaged by the company affected making the same changes under an alternative route under the Companies Act as opposed to under the Takeovers Code. And so there's a prohibition introduced on code companies using long-form amalgamations under the Companies Act. They'll have to do that, if my understanding is correct, through the Takeovers Code rather than under the Companies Act. And there are also other new changes to the voting thresholds that are required in respect of schemes of arrangement, amalgamations and compromises under Part 14 of the Companies Act, as well as a mechanism to seek a ruling, a no objection statement from the takeovers panel, which may be of assistance to the parties if they're going through a court-related process to gain some tick-off, if you like, from the takeovers panel that they don't have an objection to what's being proposed. Mr. Speaker, the other change that's made by the bill that we're supportive of is the criminalisation of certain breaches of directors' duties. There have been some terrible conduct on the part of some finance company directors that have been exposed since the global financial crisis caused a clean-out of the finance companies. Now, not all of those finance companies were being improperly governed, but some were. Some of the finance companies failed in what's been the greatest recession around the world since the Great Depression, and you would expect, following a recession like this, that there would be some finance companies that would fail and some people would lose some money. And certainly on this side of the House, we're not saying that there ought not to be some level of risk in finance companies that could come to pass that causes people a loss. We don't go that far. But where directors are so errant in their responsibilities that they are recklessly pursuing a course of conduct that they know will be putting the investors at risk in a way that isn't properly disclosed to investors, well, that's criminal. Especially where they're profiting themselves personally, where they personally or through related parties like their family trusts are profiting, and the greatest ill-gotten gains in that regard in recent years in New Zealand were probably by Mr. Petricevic, who was who really he has met some criminal penalties. But he hasn't met criminal penalties for these sorts of breaches of duties where he probably should have faced legal risk in respect of that. Now, this criminalises some of these more serious offences by introducing a term of imprisonment of up to 5 years or a fine of $200,000. And in the worst of these cases, that is absolutely appropriate.
Speaker.
I call the honourable member Russell Norman.